governments. And for those I haven't met before, I'm Amy Turner. I'm a senior fellow at the Sabin Center for Climate Change Law at Columbia Law School. And my research focuses on local level climate law and policy around the country. So I help local governments understand the legal frameworks within which their climate policies or proposed climate policies operate. So to that end, we will be talking today through the legal frameworks that are applicable to building energy labeling and disclosure requirements. And I want to be clear when we're going through this presentation, we are going to talk about frameworks. There are probably, I think there are 3 states on this call, but probably half a dozen states represented in this cohort group. And so we can't go through what the law says in all of them, but these laws are all going to work in similar ways. So what we can do over this hour is point you and your municipality's attorneys to the kinds of laws that should be reviewed. So here's a quick agenda for our conversation today. We'll talk about local legal authority, how it works, and how state preemption of local law works in a building labeling context. Then we'll talk about privacy considerations associated with building labeling and disclosure policies. We'll talk about third-party scoring systems. We'll talk about takings and regulatory takings. And then we'll talk about private contracts, enforcement mechanisms, and voluntary programs. So I want to underscore that while we are discussing these areas of law because they're relevant and it's important to make sure any policy you undertake is consistent with applicable law, local governments have a lot of legal authority when it comes to building labeling and disclosure. So we'll talk about legal concepts like takings and governmental interference with contracts, in part because these things have been raised by folks in the group and I want to be responsive to them. But please do not walk away thinking that some of these more obscure legal concepts make building disclosure laws unlawful. I want to, discuss them because they've been asked about, but not because they're going to stop you from enacting your building labeling or disclosure requirements. So please just keep that in mind. We'll go through some kind of in the weeds legal details, and I don't want you to think that in some of these instances, it's going to be like a real gating item to your policy. So the first thing we should discuss is a really basic local law concept that I'm sure a lot of you encounter in some form or another every day. I guess I will step back and talk a little bit about how local law works. So local governments are essentially very convenient political subdivisions of state governments. When you think about the federal constitution, we have our system of federal government and we have our state governments. The Constitution assigns each of those levels of government various forms of authority. It's pretty much silent on local governments. And so local governments came about as a matter of convenience. States decided that it was easier to govern within their states by delegating some of that responsibility to local governments. But local governments derive all of their authority to act from that state government. There's nothing in the Constitution that says local governments in and of themselves have authority to act. They have to have a delegation of authority from the state government to act in a certain way. So when we think about any sort of policy, and in here we're talking about the authority to regulate or require labeling and disclosure with respect to buildings, we have to find a source of authority delegated by the state government to the local government. And so, the 2 main ones, or it's really kind of one, but the 2 main ones that probably will, justify your acting to require building labeling or disclosure is through your municipal home rule authority and through your police power. So municipal home rule is a very broad grant of authority from the state to the local governments within the state to govern their own affairs. It's only in certain states, but it's in, I guess it's in most states, I should say. It's this very broad grant of authority that the state passes on to your local governments. And a really related concept is the police power, which is often delegated at the same time as home rule, not in all places, but the police power is the state or local authority to govern with respect to public health, safety, and welfare. So home rule and police power are not exactly the same, but they often overlap. Some states delegate the police power in a municipal home rule statute. However, the two are delegated. These two represent two of the really basic ways that local governments would find authority to require building labeling in this way. In particular, given the really significant health and well-being implications of building emissions and energy use, both at the global scale and more locally, like local air pollution from buildings, building labeling requirements are going to fall pretty squarely within the police power. So for most local governments, you're probably going to find, or use as your sort of hook for legal authority to enact a building labeling requirement, the police power that you've been delegated by the state government. You may have other more specific grants of authority that could justify your building labeling requirements, perhaps building code authority, zoning code authority, perhaps it would be a bit clunky, but you could include a scoring system in the building code, perhaps a delegation of authority around rental housing or housing quality. If you have that authority, you can sort of think creatively about state laws that your local governments might have authority to enact. State laws that might grant your local government authority to enact a building labeling requirement. I still think for many of you, the police power, that really basic authority to govern with respect to local health, safety, and welfare is going to be the most applicable source of authority, but I highlight a few others here in case they're helpful. So the flip side of state delegation of authority is preemption. So preemption is a legal concept that local government officials come into contact a lot with in their work. But for those who are perhaps less familiar, preemption is a legal concept in which a higher level of law blocks or displaces a lower level of law. So federal law can preempt state and local law, and state law can preempt local law. Now, federal law doesn't have much to say about building labeling. So to the extent that we are really worried about preemption here, and to be clear, I don't think there's a ton of risk, but to the extent we are worried about this, it's state law that we'll need to review for preemption. So preemption can happen in three basic ways. The first is express preemption, in which a state law explicitly says that municipalities cannot enact certain local laws. So, for example, many states with statewide building codes expressly say that local governments may not set their own building codes. That's express preemption. The second is conflict preemption, which occurs when a state law and a local law directly conflict, such that they both can't apply at the same time, and the local law is therefore invalidated. So as a totally hypothetical example, if a state law sets out all of the allowable terms for residential leases, a local law requiring disclosure of an energy score at the time of rental could be viewed by a court to conflict with that state law, and it might be struck down on these grounds. I think there's room to argue for the opposite outcome, so I'm not trying to prescribe how this would come out in court, but that's an example of conflict preemption. And then the third kind of preemption is field preemption. So field preemption happens when a state law is deemed by a court to govern so broadly in a subject matter area, or what's called a field, that local governments cannot also legislate in that space. So, for example, some states' public service laws, the laws that regulate the energy distribution system, are deemed to govern so broadly that local governments are largely barred from regulating energy distribution at all. So all of this can vary somewhat from state to state, but these are kind of the three ways that preemption can happen. I would not expect on the whole that building labeling requirements would give rise to significant preemption concerns, at least not concerns so significant that your building labeling requirement would be invalid, but you and your attorneys should do a preemption review of state law. A few potential things are at issue. So first, local government should check that state law does not fully set the terms of real estate rental or sales contracts such that additional local requirements are preempted. So if for some reason your state, just fully governs in the area of either residential rental leases or real estate sales, you're going to want to do a preemption review there. I am not saying that this is happening in your states, but it's something to review. Second, where a building labeling or disclosure requirement is paired with a substantive requirement, like a minimum or maximum required energy score or other metric, the substantive requirement could be preempted by state law, especially if your state has a statewide building code. So, if you have substantive requirements that are tacked on to your disclosure requirement, which I realize that's not what we're talking about here, but they often do go together, you'd want to review for preemption with respect to those substantive requirements. Service laws, which again regulate the energy distribution system, it's possible that they could be viewed as kind of so broad as to preempt local governments from passing energy labeling requirements. I think this is unlikely because first, building energy labeling requirements generally don't govern the building energy use itself. And even if you did have a substantive requirement paired with your disclosure requirement, I think there's a credible legal argument that the fields of building regulation and energy regulation are sufficiently distinct, so as not to give rise to field preemption. So I throw it out there, but it's not, I'm not overly worried about it. You should just do a review, particularly if there are substantive requirements associated with your disclosure requirement. And finally, it's conceivable that a state legislature could expressly preempt local building energy labeling and disclosure requirements. I think the only place that does this is Arizona, which obviously no one from Arizona is in this group, given the geography. The state of Arizona has expressly preempted local benchmarking and building disclosure requirements, oddly. So, that is conceivable, but probably not happening anywhere in the Northeast. So, to summarize, I raised the risk of preemption. You should conduct a legal review, but this is not overall a huge risk in this particular policy area, just the labeling and disclosure. Building labeling and disclosure requirements for the most part don't include substantive metrics, and local governments generally, depending on state law, have, as we discussed, pretty broad authority to govern with respect to resident health and safety. In other words, to protect from fossil fuel emissions in buildings. So, at the very least, I would think that if a preemption concern arises, it could generally be addressed in the structure of the requirement that you're developing. So it's something to keep in mind, and this is probably going to be the most fulsome part of your legal review. Any questions about privacy about preemption before we move on to privacy? And to be clear, so a home rule petition is it is a way of asking the state to pass a state level law that applies only in your local jurisdiction. So the delegation of home rule authority from the state to the local government is in theory pretty broad. Varies in every state, but it's in theory relatively broad, but it gets chipped away at by that preemption piece of it that we talked about. So what happens is that you have this broad grant of authority, and then the preemption eats and eats and eats away at it in a way that, depending on your jurisdiction and the subject matter area, can leave you with relatively little authority in a particular area. So when we talk about, natural gas prohibitions in Massachusetts, I know that folks were hoping to rely on their home rule authority, which in Massachusetts actually includes the police power. So the police power is written into the home rule delegation. But then you have a very broadly preemptive statewide building code. You have a very broadly preemptive statewide fuel gas code and a very broadly preemptive public service law, all of which were deemed to preempt in the area of natural gas prohibition. Both pieces of the analysis. You've got to find the source of authority, and then you've got to make sure that nothing preempts it. Move on to privacy, and we'll have lots of, I think we'll have ample time for questions if there are more later. So building energy labeling requirements can implicate privacy considerations. I generally would not expect these to be fatal to labeling and disclosure requirements, but we've got to think about them, and we have to consider both federal and state law. So what this really all comes from is the Fourth Amendment to the Constitution, which protects residents from unreasonable searches and seizures. So the government can't just enter your home or your car or your handbag or whatever and rifle through it unless it's reasonable, unless they have a warrant. And the government also wouldn't be allowed to do something like use a thermal imaging device to scan your home and see if you were growing marijuana in the basement. I know that sounds really off topic, but I'm just talking through some of the case law. So privacy advocates and others have raised concerns about energy use data collected by the government being a quote unquote unreasonable search and seizure. Fortunately, a federal court has considered similar issues. This is from a Seventh Circuit Court of Appeals, which is in Illinois. It's not the court that covers the Northeast, but it is, instructive case law here. So in that case, the plaintiff argued that a local requirement in Naperville, Illinois, that residents use smart meters that collected home electricity use information and fed it back to the utility every 15 minutes. The plaintiffs argued that that should constitute an unlawful search, an unreasonable search and seizure of that information. The court disagreed, and it was an interesting ruling because the court found that the data collected were considered searches for the purpose of the Fourth Amendment, but that the city of Naperville, Illinois' significant governmental interest, the modernization of the electrical grid and the reduction of building energy use, made the searches reasonable and therefore not in violation of the Constitution. So according to this reasoning, local building energy disclosure and labeling requirements would not run afoul of federal privacy protections so long as they advance a legitimate governmental interest, like reducing building energy use, promoting transparency in energy performance for renters or buyers, or some other legitimate purpose. If a local requirement were to gather more information than needed to advance this kind of legitimate interest, it's possible that that could violate the Constitution. But a building labeling or disclosure requirement can be pretty easily tailored to avoid this. So, the collection of building energy or emissions data in order to help reduce building energy use or emissions would be in line with the reasoning in the Naperville case and would therefore be constitutional from a federal perspective. Utilities, first of all, just don't want any part in this, right? Like it's an administrative burden for them and they would prefer not to. And it's going to be hard for local governments to require them to do it. Generally, utilities are regulated by state law. And so if you wanted the utility to actually provide the data, you'd have to go through state law rather than local law. So that's one piece of it. Also, I think a lot of this is not legal, it's political, right? And so, people have political concerns about their privacy when it comes to disclosing building energy use. And that's a different question than the legal question. Those advocates might use legal arguments to make their political case, but it's distinct. I imagine that the utilities are sort of co-opting some of the arguments around privacy to bolster their case that they just don't want to do this.
Okay. All right.
So in addition to federal law, we've got to think about state law. This is where we're going to be really frameworky rather than kind of state specific, because this is all really going to vary by state law, but it's going to work similarly in different places. So the things you'll want to look for in state law include state constitutional protections, so very similar to that Fourth Amendment protection, these protections against unreasonable searches and seizures in your state constitution, and any case law that interprets those constitutional provisions. You may have some additional state laws relating to privacy. You'll want to talk to your local attorneys about this, but if you are collecting individual residence level data, you'll want to make sure that that data isn't foilable, that you can't, people can't request it pursuant to a Freedom of Information law. Probably not so relevant when you're talking about like big building data, but if you're talking about like individual residence data, you may want to protect that. And that this is more political than legal, but you may want to protect that individual level residence data. And you'll want to think about data security as well if you are collecting a lot of data from building owners. If people are just putting data into Portfolio Manager or disclosing an energy score, this probably isn't really relevant. But if you're collecting very granular energy use data, like through a smart meter, for example, you'll want to make sure that you are keeping that data secure, and in particular that any contractors you're using are able to keep that data secure to avoid liability if something goes wrong. So I want to be really clear that when we talk about privacy considerations, we're only talking about data that really gets at kind of the ongoing energy use of someone's building, or in particular their home. Obviously there's a whole range of potential data that a labeling or disclosure policy might capture. So requiring disclosure of an energy use score, just like a very broad energy use score, is not going to raise Fourth Amendment concerns or probably state privacy law concerns either. It's as you think about collecting data that more individual granular level that might potentially give insight into what's going on in someone's home that you may run into issues. Not necessarily insurmountable issues, as some of the case law indicates, but you'll want to think harder about why you need a particular kind of data, how you're going to protect it, and in particular whether there's anything in your individual state's laws that has anything to say about this. We also talked about this already, but just want to highlight that this is as much of a political question as it is a legal question. So groups like the ACLU, other maybe more local groups, might make noise about infringements on privacy rights. They might even bring a lawsuit, whether or not those claims have merit. So it's worth making sure that you have the political buy-in for what you're doing, that you offer privacy protections if that's going to be kind of a real gating item to what you're doing, particularly if it's on the more onerous side of the spectrum in terms of the data that you're collecting. Okay, so another topic that's come up in this group is the use of third-party scoring systems. And, we're talking really specifically to set substantive requirements. I'm talking less about using like the HERS or HERS rating system or an Energy Star rating system or whatever, and more about if you're requiring that buildings not only disclose but achieve certain certifications. This can give rise to what's called non-delegation concerns. So the non-delegation doctrine is a legal theory that elected officials make key legislative decisions. And while they're permitted to delegate some of this decision-making authority to agencies or to other appointees, they're restricted in how much decision authority they can delegate. So I want to note that this is very state-specific. You'll need to review your state's law. But the concern here, particularly in instances where a labeling requirement includes substantive requirements, is that the government is delegating its authority to a third-party standard setter. So essentially, the government is risking that a third party will change its scoring criteria without the opportunity for elected or appointed local officials to make legislative decisions about those scoring criteria. So, for example, some places have LEED construction requirements, right? Either in the building code or in a zoning code. LEED regularly updates its scoring system. So when a local government requires that a building achieve LEED certification, it's possible and in fact even likely that LEED could then change the criteria and therefore change the underlying law without the proper democratic process. So how can we deal with the non-delegation risk? I would say the gold standard approach is to include any substantive requirements or rating system in the law or the related regulations themselves. So in other words, rather than requiring LEED certified buildings, for example, or a maximum HERS score or whatever, embedding those requirements for such a certification or score into the law or regulation expressly. This means that local elected officials or their agency appointees actually have to revisit the law or regulations in order to change them. Changes can't be kind of inadvertently delegated to this outside company. So I totally acknowledge that it is one thing to recommend something in theory and another thing to do it in practice. So, while I think that's the gold standard legal protection for non-delegation concerns, it might not always be feasible. Many local governments might lack the technical expertise to keep up with changes in the underlying criteria. In some instances, the criteria might be proprietary. It's inconvenient. It's possibly politically difficult to change laws all that often to reflect these changes in the building rating or labeling standards. So I've got a few other approaches for you. One option is to set a very broad standard in the law and then delegate to an agency how to figure out the details. Agencies in many places are more likely to be knowledgeable and have the capacity to update the regulations more easily. Again, all very context specific. In some places, the agency is not going to have the capacity to do that. But the idea here would be to set a law saying that people have to disclose home energy performance upon the sale of that home, for example, and then directing the agency to set the rules for compliance with that law. Another option would be to make sure that you leave decision-making authority about enforcement with the relevant agency. So, in this formulation, perhaps the requirement is that the building meet the requirements to achieve a certain HERS score, but the agency, rather than the private company, actually makes the decision as to whether the building complies. Again, all very context specific, may not be feasible for your Department of Buildings to do this. So a final option is just to chance it. A lot of places have lead construction requirements on the books, for example, and they just kind of pass unnoticed. So you might choose to make a decision that takes on a small amount of legal risk in order to have a program that works better. And I just, again, want to reiterate, we're really talking about programs that have substantive requirements attached to them. It's not that there's zero non-delegation risk when we're talking about simple disclosure requirements. Could have those arguments, but I think it would be a pretty weak legal argument for someone to oppose a simple disclosure requirement on non-delegation grounds. So a couple of topics I want to cover, really not because they impose legal risk. I want to be clear about that, but just because they've been asked about enough times that I think it's important we talk about them. So the first of these topics is takings and regulatory takings. So the concept of takings originates in the Fifth Amendment of the Constitution. You probably never wanted to learn this much constitutional law in your lives. But the Fifth Amendment of the Constitution says, "Nor shall any private property be taken for public use without just compensation." So this is the takings clause, is what it's called. And the takings clause has been interpreted to apply to both physical and regulatory takings, which we'll get to in a second. Physical takings are really straightforward. The government, whether it's federal, state, or local, takes the private property, like it uses eminent domain, basically. The government is allowed to do this, but it has to compensate the property owner. It has to provide just compensation. Disclosure and labeling requirements obviously don't contemplate any transfer of property, and so, definitely not worried about physical takings here. Regulatory takings. Regulatory takings are a form of a taking that occurs when a law, regulation, or other government action effectively deprives a property owner of their property, even though the ownership of the property doesn't change hands. So just like with physical takings, the government is permitted to cause a regulatory taking so long as it provides just compensation. But generally, we're trying not to do that because compensating the property owner can be really expensive. We don't want to do that. So, under federal law and a lot of state laws, the specific wording might vary, but under state law, the test is that a regulatory taking happens when the regulation deprives the property owner of, quote, all economically viable use of his land. So an example of this is, there was a coastal zone management act in South Carolina that prevented a property owner from building a home on his beachfront property. That was considered a regulatory taking that required just compensation. Other times that people have tried to claim that they were subject to a regulatory taking and were not successful were, for example, a building in New York City couldn't transfer its development rights in a certain way that it wanted to, but it could still develop the property. In other instances, the price of gasoline in Hawaii was regulated in a certain way that made it harder for the gasoline company to make money, but it was not deemed a regulatory taking. The law affecting a regulatory taking, for it to be deemed a regulatory taking by a court, would have to completely deprive the person of the value of their property. There is just almost no way that a building labeling requirement would do this. This is not even something I would normally include in this presentation, but it has been asked about so many times that I think it's important. I'll just share this quote from some of the case law on regulatory takings. This is an old case, 100 years old now, but this rule stands. The general rule, at least, is that while property may be regulated to a certain extent, if regulation goes too far, it will be recognized as a taking. So what this says is you can regulate property. Your local governments do it all the time. Zoning limits uses of property, for example. You're allowed to regulate consistent with your police power, which is what this is. So you are allowed to impose requirements on private property. You just can't do it in such an onerous way that it deprives folks of the economic benefit of their property. There's just like almost no way that a building labeling requirement would do this. So another area that I want to cover, again, not because I'm concerned about it from a legal standpoint, but because questions have arisen, is the issue of governmental interference with private contracts. So this question would arise in the context of disclosures required prior to or upon the rental or sale of a piece of property. So time of sale or time of rental disclosure requirements. These requirements, again, highly unlikely to interfere with private contracts in a way that renders them unlawful. So in particular, labeling and disclosure requirements are only going to apply prospectively. They're not going to look backwards. They're not going to be retroactive. And so they should not give rise to concerns about interference with a private contract. So just, again, some more constitutional law. Concerns about governmental interference with a contract are the subject of the, quote, contracts clause of the US Constitution, which states that no state shall pass any law impairing the obligation of contracts. But courts have interpreted the contracts clause over the years in a pretty limited way, and state and local governments, consistent with their legal authority delegated by the states, are able to exercise their police powers in ways that touch on private contracts. Formally, courts will consider a three-part inquiry, whether there's a contractual relationship, whether a change in law impairs that contractual relationship, and whether the impairment is substantial. So to take just the first part of this three-pronged test, the question of whether there is a contractual relationship, this refers to existing contracts, and building, labeling, and disclosure requirements would only apply prospectively. So there's simply no existing contract that you would be interfering with. I should have made this slide a lot clearer instead I just put a bunch of text up here, but the takeaway is there's no existing contract. Even if there were a contract and that law impairs the contract, let me just move this for a second. It wouldn't be deemed unconstitutional as long as it's justified by a, quote, significant and legitimate public purpose, which again, you have a significant and legitimate public purpose here. So, in other words, a disclosure requirement, it wouldn't apply to existing contracts in the first place. So there's no contractual relationship to interfere with, and it's simply essentially not a big enough deal to impair a contract so substantially as to be unjustified by a public purpose. I will point out that states also have contract clauses in their constitutions. If they don't have a specific contract clause, they might have a prohibition on retroactive laws. New Hampshire, for example, doesn't have a contract clause specifically, but it prohibits retroactive laws, and that's a very closely related concept. You can't have a law that applies to things that have already happened for the most part. So you'll want to review your state law as well, but I really just don't think it's going to be an issue. We're not talking about regulating or interfering with existing contracts. We're talking about, placing certain requirements on future contracts, which is very different and something that, is very much within your police power to do. So enforcement and penalties, this has been discussed a little bit among cohort members as well. So likely most members of the cohort have local laws in place that set standard penalties for violations of law. For the most part, those penalties could be applied to violations of a local building energy or labeling or disclosure law. To the extent that a local government is considering going outside of any standard penalty provisions, you should confirm that you're doing that in a way that's consistent with state law. A good practice is to make sure that the penalty is reasonable. I won't subject you to more constitutional law, but maybe I will actually. The Eighth Amendment prohibits, cruel and unusual punishments. So you can't have fines that are totally unreasonable. But assuming that you're not thinking about doing that, you probably have a penalty regime in place that could be used here. I've had a couple of questions about voluntary programs as well. So, many of the legal issues that we've discussed today apply only or largely to mandatory building energy labeling and disclosure requirements, not to voluntary programs. As an example, a handful of places have experimented with voluntary benchmarking programs that allow building owners to assess their building energy performance, compare it to other buildings, get used to portfolio manager, acclimate to benchmarking, and then maybe the city comes in later and imposes an actual benchmarking mandate. If you're collecting sensitive data, you'll want to ensure that you've got systems in place to keep that data secure. You may be using incentives, so totally voluntary, but the person gets a sweetener for participating. This is going to entail a slightly different analysis, but mostly not going to lead to the legal issues that we've been talking about. For the most part, reasonable incentives in exchange for participation in a disclosure or labeling program would be totally acceptable. You could think about a local government, maybe offering a utility discount or building upgrade incentives for buildings that make their energy score public. A local government could offer to pay for energy audits or assessments. It's conceivable, very, very unlikely, conceivable that a disclosure or labeling requirement could offer, or a voluntary program, a disclosure or labeling voluntary program could offer such a large incentive that participation is nominally voluntary, but would be deemed a de facto mandate by a court, potentially opening us up to all the legal issues we've already discussed. I just think this is really, really unlikely. Essentially, to be considered a de facto mandate, the voluntary program would have to make it so onerous not to participate that there was really no choice other than to participate. And I just don't think, for the most part, that that's what we're talking about here. So I hope that what you are taking away from this is that there's a lot of room for local governments to enact building labeling and disclosure requirements, at least from a legal perspective. You'll want to identify a source of legal authority for what you do, probably the police power, and you'll want to do a state-specific review with respect to any state laws that preempt what you're considering doing. But beyond this, you'll find a good deal of legal authority to enact the kind of building labeling and disclosure requirements that you want to enact. So I'll end there. Thanks everyone for listening. I'll stop sharing my